Okay, chapter 7, slide part 4, talking about product liability. And in addition to applying strict liability, you can try and sue for negligence as well. And you can look at the same kinds of things and try and prove that the manufacturer or seller was negligent in some way. Okay, other theories with warnings, you can have a misrepresentation. That occurs when fraud is committed against the consumer or user of a product. So if the seller tells you that this product is safe to use for this purpose, and it turns out it's not and it harms you, then that's a cause of action. It has to be made knowingly or with reckless disregard for safety. You don't have to show that the product was defective. You only have to show that what the person told you was untrue, made knowingly and with disregard for the safety, and that you were injured as a result of using the product in that way. In looking at safety features, the courts look at the expense of installing a particular feature in comparison with the cost of the product and magnitude of the danger. In other words, if you are injured and you go to a lawyer and the lawyer's looking at whether or not you would have not been injured had there been a certain safety feature, the lawyer's going to have to show that the manufacturer looked at the cost of putting that safety feature on versus the magnitude of the danger by not having that safety feature. And that's what the court's going to look at in terms of trying to decide liability. One of the ways that they look at that is what's called market share liability. This is a little bit more beyond the scope of what we really need in a business law course, but you can read what it says and how that works. And other applications of strict liability, as we said, extends to injured bystanders and applies to component parts for both the manufacturer and of the component part and the manufacturer of the whole product. Okay, so what are some of the defenses to strict liability? Preemption. Preemption means that the government has issued some regulation or rule, and you've conformed your product to that rule. In some of those instances, then you are not liable because you're basically saying, I met the safety requirements of the government. Misuse. If the plaintiff misused the product and that contributed to the injury or caused the injury. Contributory negligence, comparative negligence, assumption of the risk. All the same things that apply in a negligence case would also apply in strict liability. Obvious hazard, that would be one. Statute of limitations, of course you have a certain amount of time in which to bring your lawsuit against the manufacturer. A sort of exception to that is what's called the statute of repose. Okay, so this is a rare instance where you buy a product and perhaps don't use it or open it for a number of years. And then you open it and it causes injury. Well, in those situations, the courts set up a rule that protects the manufacturer because the manufacturer kind of expects people to use the product right away. And so it's sort of like the statute of limitations and is a defense. We talked about preemption, talked about misuse, comparative negligence, assumption of the risk, commonly known dangers, electrical shock. I'm not sure I don't think they have to put a warning on a electrical outlet warning you that if you stick your finger in there you're going to get shocked and possibly injured. We talked about the statute of limitations. When does that run? The statute of repose. Okay, so it dates from the sale of the product instead of when the injury occurs. And that's to protect you if the product is not used right away. Okay, so that finishes up Chapter 7. Again, the magic word for Chapter 7 is absolute. Thank you very much.